Hello, everybody. Welcome to Beyond Borders with Mary Kennedy. Today, we are with attorney Mary Kennedy, an attorney with over 23 years of experience in the immigration scape. And she is joined by our paralegal, Sanjana. And we're here to clarify any questions that you may have with how the new administration is going to affect immigration and immigration law. Let's go right ahead with all the frequently asked questions that have come up to us.
Ms. Kennedy, let's start with the big picture. What major changes do you think we could expect in the employment-based immigration under the new administration? Are there any areas you anticipate will be impacted immediately versus those that might take longer to roll out?
Hello everyone, this is Mary Kennedy. Is Sanjana. We are likely to see a shift in policy direction with a greater focus on skill-based immigration. And the immediate impacts could include stricter enforcement of employer compliance, changes to prevailing wage requirements, and increased scrutiny on visa petitions to ensure adherence to their regulation. And the longer-term results might involve legislative efforts to modify the number of available visas and create a new pathway for high-demand skill sets. Employers should start preparing by reviewing their compliance practices. And we are a very big proponent, and we had been advising this for a while to our employers and staying informed about the policy changes and the shift that's going to happen.
Thank you, Ms. Kennedy. I have a follow-up question here. When will these changes actually start to affect employers, employees, and visa applicants?
So the policy changes that come through, different means, the executive actions or the policy memos, and they can be effective immediately or weeks or months. However, the legislative changes, that's going to be much longer. And depending on even sometimes years it might take, depending on the political climate and the bipartisan support. It's very crucial for the employers and the visa applicants to closely monitor the announcements.
Thank you, Ms. Kennedy. Let's dive into the H-1B program specifically. Since it's such a key area for many of our listeners, what specific changes do you think are coming for H-1Bs? Any stricter standards or higher denial rates, something we should be preparing for? Will they make a significant adjustment when it comes to H-1Bs?
Yes, for sure. Stricter standards and higher denial rates are likely under the new administration. We have experienced it in 2016, and so it's not going to be something very different. We might see increased scrutiny of job descriptions, wage levels, and employer-employee relationships. There is also a possibility of reforms aimed to curbing abuse and prioritizing higher wage, higher skill jobs in the H-1B selection process. That's all something we have to anticipate, and we are preparing ourselves for it.
Thank you for breaking that down now. On this note, how do you think these changes will affect tech companies specifically, given how much that they rely on H-1B talent? What kind of adjustments will they need to make to their hiring practices?
Yeah, the tech companies may face challenges in maintaining their current talent position. They'll need to plan for longer processing times and more documentation to support H-1B applications. Companies might also consider diversifying their hiring strategies by exploring alternate visa categories or increasing offshore operations. That's something very important for them to plan it out right now.
Thank you, Ms. Kennedy. So, regarding processing times, we've heard a lot of concerns about delays in processing times under the new administration. There was a period where they temporarily stopped premium processing. What's your advice to employers and visa applicants for planning ahead when it comes to navigating longer processing times or stricter reviews?
Yes, employers should file the application as early as possible, anticipating delays and then building contingencies into their hiring timelines. For visa applicants, it's very important to ensure documentation is thorough and accurate to avoid requests for evidence or denials, and premium processing, if available, can also be a valuable option to expedite the cases.
To add on to that, Mrs. Kennedy, how do you see these changes specifically affecting the technological sectors?
So the processing delays could disrupt project timelines and create gaps in the critical roles, right? The clients as well will be in need of this position, which is what most of the companies, the consulting companies hiring the H-1Bs. So they have to invest in more of an immigration support team, so partner with experienced legal counsel to streamline the process and maintain compliance. And more important is if the premium processing is available, that right now is the time for them to invest on that, the additional, the fees, and then do the process as soon as possible.
So, Ms. Kennedy, how should companies in the tech sector or even other industries adjust their compliance and documentation practices to stay ahead of these changes? When it comes to things like LCAs, maintaining public access files, doing I-9 audits, what is your input on that?
Training the HR teams or educating them on their rights, and as well as how do they collaborate the immigration attorneys, will definitely help them in the mitigating the risk that is involved. We have seen a very high frequency of the FDNS audits. As we discussed about it earlier, I'm a big proponent of conservative and compliance-wise employers to follow what needs to be in place, irrespective of any expectations of audits or even FDNS visits. So keeping that in mind, so this is the time for them to internally do those audits and keep the process in place.
Thank you, Ms. Kennedy. So, Ms. Kennedy, there's been a lot of talk about potential restrictions on H4 EAD or even the possible elimination of H4 EAD. How can these families who rely on these work authorizations prepare?
Yes, there is a lot of calls and then follow-ups to our office as well, for the H4 EAD. Even in the social media, we see that lot of clarification. Unfortunately, we don't have a solid answer for this at this time, but all that our thoughts are, or my advice is, while there has been restricting or eliminating the H4 EAD, such changes would likely face significant legal challenges. Families should consider always as an alternate option, such as exploring independent visa categories. If the person has been earlier on a H1B, and if you find it's reasonable for you to change your status to that of the H1B, the premium processing as well is available. And then if you earlier at any point of time in your stay in US had a H1B, you all know that you can qualify yourself as a H1B cap exempt. So this is the time for you to explore that option. See, this is very individual basis advice. So you need to talk to your counsel and find out the options and go for a premium processing and secure your H1B for the 3 years. But again, coming back to the H4 EAD, definitely it's not going to be a weekly or a monthly change that is anticipated. We definitely are looking at legislative changes, and then it's going to take time to do that. So be assured it's not going to happen immediately. So wait for any updates on that, and we'll definitely be there to guide you on that.
Thank you, Ms. Kennedy. So there's been a lot of talk about the possibility of ending birthright citizenship. While this would require a lot of legal roadblocks and challenges, what do you think the implications could be if this were pursued? How should families with children born in the US prepare for any potential uncertainty?
Yeah, I do see the same concern as same compared to the H4. And then the second question that's asked is the birthright citizenship. Revoking the birthright citizenship would require constitutional changes, making it a complex and a lengthy process. However, families should ensure that they maintain through records of their immigration status and seek legal advice if does any changes we are expecting, and then it's going to gain momentum. The main concern over here is is it going to be retroactively affecting people who had their birthright citizenship, because there are so many non-immigrant visa holders like H1Bs, L1s, and then even some of them coming here on a B2 and then they had their children and they are citizens. How does it affect? As with the longer processing timeline of the employment-based green cards, so there even our office had helped so many people on to get their green cards by their children who are born here, got the US citizenship. After 21, they are able to file it for their parents. So all those are very questionable, and that's a concern that's raising. That's not going to happen as soon as it's expected, and then it's not going to be retroactive. Is going to be very, very tough in this scenario. So we should not be worrying about having an unknown fear of worrying about something that's going to be taking a very long, lengthy constitutional process actually. So we should be focusing, if in case of it's going to be gaining momentum in the coming months after the new government gets elected on January 20th. We have to just look for the changes and wait for it in the process, understanding how do you mitigate if in case it's going to affect you. That's what I would say. Just wait on it till we learn something, know something, and then we can definitely update you on that.
That's a very reassuring perspective, Ms. Kennedy. Thank you for sharing.
As we discussed, and the reason for this podcast as well is, stay updated of the policy changes. And we are as well planning for any updates on a frequent basis. So definitely follow us up, and then we will be talking about any updates and communications with affected employees, as well